So we're going to get started here. A couple considerations that we want you to have, all right? Like we always talk about, there is no replacement for reading actual statute, okay? So if you go into court and you say, well, Tyson said this at spring conference, that may not be a particularly effective and persuasive argument to your judge if I tell you something wrong today, which there's a significantly good chance that I'm going to make something up along the way today because Eric's going to ask me a question that I don't know the answer to, but I have to pretend like I do, right? So you need to read these bills, and the legislative summaries are in there. Unless otherwise stated, these bills all go into effect on May 4th. All right, that's the effective date, the general implementation date for these bills, and that is when they will be going into effect, unless we tell you otherwise. There's a few that have different implementation dates, but most are that day. Page numbers in the legislative summary are on the slide. Almost all of them will be in the top left corner, but because of some of the slides and the design on some of the slides, it didn't always work out that way. There'll be a number like in the top right corner. We're all adults, you can figure it out. I have faith in every single person in this room that you'll be able to do that. So without further ado, if you have questions, please ask. I had told Representative Stoddard, Andrew, I said we're going to flip all questions to him, but he actually had to step out, so he's not here. Convenient, for sure. Anyways.
All right, let's get started. How many of you have done a jury trial in justice court? By the raise of hands. All right, by the raise of hands, how many of you have done a DV jury trial in justice court? How many of you that have done a DV trial in justice court got a de novo appeal after a conviction? Well, House Bill 196 is for you. House Bill 196 is a DV transfer bill. What it says is that when a justice court case is domestic violence and it's set for trial, either the prosecutor or the defendant can notify the court that it is being transferred to the district court. So transferred from a justice court not of record to a district court of record. I think you all understand the benefit of this. I know we just said that all the bills start May 4th. This one doesn't. This starts July 1st of this year. It's also a short-term pilot project to see if it works. So it is in effect for a few years. Take advantage of it. Exercise. Everyone should have a right to a trial. No one should have a right to two trials. Yes?
You said set for trial.
Set for trial.
So that means the defendant or the defense actually has a trial date set?
That's right. So if you're in a court where at the initial appearance, the judge just says, all right, well, here's where our scheduling conference is going to be, and we're going to schedule a date for trial in 8 months or 9 months, and get ready, everybody, then the time that it's set for trial is the time that you filed that notice of transfer. The Advisory Committee on the Rules of Criminal Procedure is already putting together a draft rule for how that notice can be submitted, but this is not a motion to transfer because it's not something that can be denied. It's a notice of transfer.
Two questions. Is it just juries or bench trials also? And then does it apply to pending cases or only cases filed after July 1?
Fantastic questions. It applies to anything set for trial, bench or jury. A notice can be filed. Also, anything that goes to trial before July 1st, you're out of luck. But anything scheduled for trial after July 1st, or that will be scheduled for trial after July 1st, you can file the notice of transfer.
So delay all your cases till after July 1st.
That's right.
It is set for trial, it goes to district court, and before trial, it comes to resolution. Is it sentenced in district court, or does it go back down to justice?
It is sentenced in district court. This is a one-way street, and you can't play shenanigans. Let's say you've got a judge in justice court that loves to sentence DV, and the defense attorney knows that and wants it in district court. You cannot move to dismiss the case in district court and then refile it again in justice court. Once that case is transferred to district court, it is a district court case from then on, even if dismissed and later refiled.
Can the district court reconsider any motion, any pretrial matters?
That is going to be addressed in the rule. It's not explicitly stated in the statute, but the idea at this point is that the law of the case will be transferred as well. So to the extent the justice court judge has made rulings, those will continue to be the rulings, although anybody can ask the district court judge to reconsider. Fantastic feedback, everybody. Wonderful. We only have 42 more bills to go.
Last question. So when it is transferred, can the justice court attorney go with it to district court, or does it transfer to like a district court attorney transferring the office of prosecutor?
Great question. So just because it's transferring from justice court to district court does not mean that the jurisdiction of the prosecutor changes. And that may be a burden. If you are in a justice court where the district court is far away, that might be a reason that you don't want to do these transfers. But it's your case, even if it gets transferred.
And I have one that just does not even compare to that, but nonetheless, take note. Aggravated unlawful distribution of a counterfeit image. So this is where we've got bodies and heads getting attached that don't initially belong together. And I always say, if you're going to do that, please make me taller, skinnier, and younger. We can now only charge that for individuals committing that offense 18 years of age and older. So we cannot charge that as a juvenile offense.
House Bill 29 is a bill that actually Will kind of took the reins on this. It started last year and was a really terrible idea by a legislator, and we were able to convince that legislator. When I say we, it was mostly Will. And then
You were on the working group. It's your fault too.
to hold off on what she was trying to do and to do something better the next year, which she did. A collaborative process here. So you all know that there are several different code sections and titles where we can charge DUI with causing injury or death, right? There's some in 5837.8, there's some in 4168.503, there's some in the automobile homicide statute, right? And they're all these different places, and we would have different results based upon which statute the prosecutor decided to charge. We'd have different results based upon what substance somebody would take. In that, we had different penalties for alcohol or marijuana or meth, so to say, and they just weren't consistent. And so the idea here was to create consistency in our code. It wasn't a prosecution-friendly move. It wasn't a defense-friendly move. It was a move to say, we need to make things consistent. So all of your DUI-related, so DUI or driving with a measurable controlled substance, offenses with injury or death have been moved out of where they currently were, except for the automobile homicide, which I'll get to that in just a second. And they're now all in Title 76, okay? And so we have automobile homicide will no longer be called automobile homicide. It's going to be called negligently operating a vehicle causing death, all right? And there's some statutes that got moved into that. We're going to cover this. There's no more like DUI with an injury. That's negligently operating a vehicle causing injury, all right? Those are our two new statutes that we're going to be focused on here with this. There's some nuance that goes along with this, but basically what we're talking about is if there's DUI or driving with measurable controlled substance and an injury, bodily injury, that will be a Class A misdemeanor, no matter what the substance is, all right? If there's serious bodily injury, it will be a third-degree felony, no matter what the substance is. If there's a death, then that's a second-degree felony, no matter what the substance is. So that's the consistency. Where the nuance comes in here is we need negligence, right? In these cases, it's not just DUI and a death, so we're there. It has to be negligence causing that injury or death, right? That's what the statute says. So if it's a true DUI case, if we're talking about somebody that's over 0.05 with their BAC, or they're incapable of safely operating a vehicle, then that's a DUI, right? If we have that, where we have the impairment or that per se over an 05, then we're talking just simple negligence. That's the standard that we have to prove, that there was negligence that caused this injury, serious bodily injury, or death, all right? If we don't have that impairment, we don't have somebody over an 05, and we're going under the driving with a measurable controlled substance standard, it requires criminal negligence to get that same level of offense, all right? Does that make sense? Can you see how that created consistency across the board for these offenses? And it makes it much easier to navigate these things, to have it. We're hopefully going to get more consistency in sentencing because of this as well. And it was just patently ridiculous that somebody could do something with meth and marijuana and have completely different results just because they decided to use a different controlled substance. And so the idea was consistency, and I think we really came out with that. So be aware of that. May 4th, all these changes go into effect, and it will be good as we move forward for the consistency of that.
Throughout history, there have been people who speak out when they see something wrong. Sometimes they are called royalty, other times outcasts. In some eras, they've been called prophets, and in this era, they are called Craig Barlow. Craig Barlow, for over a decade, has been warning the Sentencing Commission that property crimes are not treated appropriately under the sentencing matrix. If you've ever had a super high value crime where 50 or 500,000 or $5 million has been taken, you realize that the sentencing guidelines stopped at $5,000. And that is wrong. And with the help of Dan Strong from the Sentencing Commission, we got passage of House Bill 229. This is an interesting book if anybody's interested. The rich get richer and the poor get prison. It's a conflict theory approach to criminal justice, and it suggests that those who commit really dangerous crimes don't get punished because they're in a different caliber. And House Bill 229 tells the Sentencing Commission, when you commit a really high-value crime, over $50,000, you need your own set of sentencing guidelines. I've seen a glimpse at those guidelines, and they will be coming out soon. They provide a lot more consequences when you take a lot of money, whether from one individual victim or from several victims. This is a fantastic change. Also, it increases the penalty if you lie on your declaration form as far as paying restitution. It's amazing that when someone wants a public defender, they don't have a job. But by the time sentencing comes around, they all have full-time jobs. And they can't go to jail because they'll lose their job. Well, this says if you lie on that financial declaration form for restitution, it is no longer a Class B misdemeanor, it is a felony. Additionally, it provides subpoena powers to prosecutors if you believe that there's resources that are being hidden in order to avoid paying restitution. You do have increased authority to find out what property that person owns. Fantastic bill.
Okay, so another shift as far as how we handle cases involves our prostitution and sexual solicitation crime categories. The focus here, they're trying to shift it towards the demand for these kinds of crimes. So what you're going to see in the statute is a limitation of the elements down to a single element for the crime of prostitution, and that just involves the engaging in sexual activity for a fee or equivalent, functional equivalent of a fee. Then you will see some additional elements added to solicitation, sexual solicitation, including the taking steps to arrange a meeting, et cetera, and loitering in an effort to engage in sexual activity. Penalties for both of those have also been adjusted. There will be some lowering and some increasing, so take a look at that because it will also depend on how many priors have been committed of those crimes. And then finally, there will be required court-approved courses or classes for individuals to take who are convicted of these offenses. The prostitution will focus more on providing aid, intervention, support, resources, that kind of information to try and help someone get on a path that does not include prostitution. And then the solicitation and others engaging, the Johns engaging in that, or the Janes, as the case may be, they will be having a different approach because they need a different approach as to try and deal with the issues that are motivating them to engage in these crimes. So kind of an interesting shift.
House Bill 139, this is basically what this does, okay, is creates a statewide plea and abeyance program without creating a statewide plea and abeyance program, all right? How many people remember when we used to have traffic referees in our courts, right? And how many people remember when the court removed our ability to have traffic referees? Did anybody else become a traffic referee as a prosecutor when that happened? I did. All right, in the city I was working for at the time, I became the traffic referee. And so I wish this bill would have passed 10 years ago so that when they made that change, I didn't have to deal with all these traffic cases as a traffic referee. Now, why I say this creates a plea and abeyance program without creating a plea and abeyance program is because the legislature can't tell us as prosecutors that we have to enter into a plea and abeyance program, right? So they're calling it deferred prosecution. So essentially, if you get a moving violation, a traffic infraction, okay? If you haven't had a traffic infraction in the last 2 years and you don't meet one of these 11 different things that exclude you from being able to get it. And they're in the summaries. I'm not going to go through what all those are today. They're in your legislative summaries. But there are people who won't qualify, like you're under 21, you're a CDL holder, you have multiple traffic offenses in the same criminal or episode there, right? So there's things that disqualify you. But if you don't fit into that, and you qualify for this, you will get deferred prosecution automatically. You can contact the court, you can go through their system, pay the fee that you have to pay the $25 fee to the state that they're gonna make you charge, and then you go on deferred prosecution for 12 months. Okay? It's basically a plea in abeyance without it being a plea in abeyance. Wes, you had a question?
Yeah, whose job is that to inform the defendant that this is an option? Because typically, they know what plea in abeyance is, it's been around for a long time, but is it going to be on the court to say, hey, you qualify for this program?
So it'll be something that somebody's going to be able to go in on their own to the courts and do, like the court's website. Who's marketing this for them? I don't know. I don't know the answer to that. I don't know that they're updating the citations. There's nothing to update like citations with it. But it's something that as a driver, I mean, it's like anything else, right? We expect people to know the law. And if they want to avail themselves of this, then they can know the law and avail themselves of it, right? I guess. I don't know. But it's something that they're just going to be able to go, the AOC is going to run this entire process. They got some funding to be able to do it and run it through their website. The courts are going to be checking at the end of these to make sure somebody doesn't violate. And if they do, it goes in, right? It goes in as a conviction, just like a plea in abeyance would. So should reduce a lot of traffic headaches for our justice court prosecutors that see a lot of traffic. It won't reduce everything because there is quite a list that will exclude you. On there, but it should reduce quite a bit of the work that you see when you're dealing strictly with just a traffic offense on that. So,
Last year, adult probation and parole was put in the crosshairs, and there were a few reasons for that. One, there was someone who had recently been paroled that ended up killing somebody in Davis County. And then when questions were raised by legislators in a hearing, AP&P said, if we knock on a probationer or a parolee's door and they don't answer, we mark that as a successful visit. And that didn't go over well with the Utah State Legislature. That's what led to House Bill 28. House Bill 28 really focuses on what happens when somebody has been sentenced or is on probation. First, the jail has to detain an individual for up to 24 hours after booking. If the jail knows that that person is on supervised probation or is on parole, and the arrest is for either a qualifying domestic violence offense, which means any DV other than criminal mischief, or a violent felony. Also, starting July 1st, there's new burdens on private probation providers. How many of you work in a jurisdiction where the county has some sort of probation or supervision power? So several of you. Any of you who are in those counties, starting July 1st, private probation providers cannot operate in your counties unless they have a contract with your county. It's a big change. Also, if they enter that contract, they have to report data to your sheriffs. Your sheriffs may not know that they're going to be getting some of this data. The legislation doesn't say who in the county the private probation providers have to contract with, but since they have to report to the sheriffs, it may make sense that the sheriff's department be the agency that does the contracting. If you're in a jurisdiction where your county doesn't offer any of these services, there's no contract requirement, and private probation providers will still be available. But if you're in a county where there are probation services, like here in Salt Lake County, there's criminal justice services, then you're going to need to verify before you put someone on private probation that that provider is contracted with your county. The Department of Corrections has to notify victims of their rights for continuous protective orders, which is something that has been in place, but there's been no notification requirement beyond what the prosecutor says. So now the Department of Corrections has to join in notifying them. This bill also authorizes law enforcement agencies other than the Department of Corrections to perform pre-sentence investigations. Finally, the incarceration guidelines for probation violations can be deviated from by judges, either upward deviations or downward. All the judge has to do is explain why they're deviating. So the guidelines are not mandates when it comes to probation violations. Judges can depart, they just need to explain why.
Sorry. Okay, so House Bill 134. I'm just curious, how many of you remember practicing as prosecutors before victims had rights? Before it was part of it? few hands, been around a long time. In so many ways, this has improved our ability to prosecute cases, but it absolutely has improved victims' opportunity and ability to move forward in their healing. There's been some changes, very little over the years, but there is a change this year, and it's in House Bill 134. And what it addresses likely may not change what you're already doing, but it does codify a responsibility that we have as prosecutors. If there's going to be a plea negotiation in a case, we shall, it's not optional, we shall notify the victim prior and as soon as practicable is the wording. And upon their request, the details about that plea offer, we shall, again, explain what those details are to them so that they can be informed, they can be involved. Some of you, perhaps, and I can remember having conversations with victims where my case was going to resolve in a way that I knew wasn't what they wanted, but based on evidence, limitations, or other obstacles, it was the best we could do and the best outcome we could get. And I remember talking to, and I would encourage you to encourage your victims to know that this is their time to address the court. This is their time to speak and to say whatever they needed to. And I have told victims, if you want to say bad things about me, do it. I want you to say anything you need to say today so that as you walk out that door, you can continue on in your process. So this notification and keeping our victims and allowing them the right and supporting them in their right to be heard is so important. Whether we ultimately get the guilty plea and someone goes to prison, or we plead it down to something that we're limited to but they're not happy with, we want them to be able to continue to move forward in their life the best way that they can. So this is a really important bill for victims, and I just wanted to put on your radar. And hopefully, again, this is something that most of your offices are already doing, but it's now codified and we shall do it.
House Bill 38, property theft amendments. This idea of stealing catalytic converters has become a big deal around the country, in our state, everywhere else, right? They talk about that these thieves who go and do this with the proper tool, which is a basic saw. They can do it with a hacksaw. They can do it with a little small circular saw. They can get a catalytic converter off your car in less than 30 seconds. And so this has become a big business for these thieves who go out and then go and pawn or sell or do however they do it, right? And so the legislature addressed this. This bill does a few different things when it comes to catalytic converters, all right? First, we all are aware, and I don't know that there's very many people who actually know the rules for this, but we're all aware that rules exist for pawn shops and secondhand merchandise, right? And many of those things that apply for pawn shops and things, the way that they have to document and the information they have to keep on file and ID and different things like that at pawn shops is now going to apply for catalytic converter purchasers, okay? There's now a catalytic converter purchaser in code. If you don't do that, if the catalytic converter purchaser doesn't do that, there's penalties associated with that. Same way for pawn shops, secondhand merchandise people as well. Makes theft of a catalytic converter a third-degree felony. So if we catch these people who are stealing the catalytic converters, the theft itself is a third-degree felony, and then it modifies some of the language for those purchasers again. But just realize this is a big issue. Like, this has become a big deal. I haven't verified this. This is the thing I'm going to make up, Eric, and just act like I know what I'm talking about. No. Somebody the other day told me that they had talked to mechanics that are like 6 months out on being able to get a replacement catalytic converter right now. And so if your catalytic converter goes missing and you go to your mechanic and say, hey, I need a new catalytic converter, they're like, okay, we'll put you on a list. In 6 months, we might be able to get you one, right? And so this becomes kind of a bit, not just the cost, but the inconvenience of having to wait for that and driving around without one and everything else. So big deal, third-degree felonies all around, yes?
If we can't prove the actual theft, does it change the possession of stolen property?
I do not believe it changed possession of stolen property, but we can look into that. I don't think it did.
Just go off the value of the catalytic converter?
Yeah, I think that's how you do it. Yeah, I don't know how much they cost, so I hope I don't have to find that out. Maybe somebody should go check my car right now to make sure it's still there. I don't know. So, but yeah, catalytic converters, big deal going on right now.
And now it's time for another episode of Fathers Knows Best, or as the Utah legislature likes to call it, the legislature knows best. This bill, Senate Bill 179, Criminal Justice Amendments, is a bill where the Utah State Legislature said, hey, you know, criminal justice coordinating councils are a good idea. Salt Lake County seems pretty cool. So let's change how Salt Lake County does theirs and make everybody else do it too. What this bill says is that every county either has to have their own criminal justice coordinating council or has to contract with other counties around them to create a multi-county criminal justice coordinating council. If you don't, starting July of next year, you won't be able to get any grant funding from CCJJ. Additionally, prosecutors already have to report certain things, like the number of cases filed, how many are declined, plea offers. This came from Representative Judkins a few years ago. If you haven't been submitting those quarterly reports, starting July of next year, you're not going to be able to get any grant funding from CCJJ.
Well, I think that deadline wasn't moved out to January of 23 for the loss of funding.
It's July of 23.
Oh, that's right. Thank you.
Yes. So originally, you were SOL right away if you didn't do these things. So we did get it pushed till not just July of this year, but July of next year. Having said that, if you're not currently reporting administrative subpoenas or all the things from Representative Judkins' bill, start reporting it, because beginning July of next year, you'll be disqualified from grants from CCJJ, and your counties will be disqualified if you don't have a criminal justice coordinating council. Bob?
Will that apply, for example, with our new prosecutors? The counties aren't directly receiving funding, we're getting it, at least the licenses, will it affect that?
It's a fair question. Like, if, to the extent that the county is the beneficiary of that grant funding, they may end up being on the hook if they're not providing. And it's not enough that you just have a criminal justice coordinating council. This says who has to be in charge. It says what they have to do. And to be clear, I love Salt Lake County's CJAC. If you want to Google right now the Salt Lake County Jail Dashboard, you can see how many people are currently in the Salt Lake County Jail and what they're in for, whether that's pre-adjudication or post, what kind of crimes. This is all amazing stuff that exists because of Criminal Justice Coordinating Council in Salt Lake County. It's a great idea. This takes a great idea and makes it a mandatory, unfunded requirement.
Okay, House Bill 159. This reflects back to HB 281 from 2020. So this was, as you may recall, where a victim can request review by law enforcement, then county attorney, then up to the Attorney General's office. There's a process and time periods with each stages of that request. There's been some question or concerns, and so this is just a clarifying bill that indicates that if you are, so for us in our offices, if we have a case that has gone to the Attorney General's office for the 281 review, the de novo review, we have to share all of our information, anything that we have, regardless of whether or not we created that document. So law enforcement information that we have, we would pass all of that on to the Attorney General's office. There's 14 days that we have to do that. You know, if there's issues or obstacles, obviously there can be some discussion and some work around with that. But ultimately, in order to make sure that the AG's office gets the information, which it's not the AG's office, it's the victims, to ensure that the victims have a chance to have an accurate and complete review of their case, then we have to provide that to them, or the AG's office can get a court order in order to enforce that review.
Alex, you got a question over here?
Yes?
That does not include our work product, however, correct?
That does not include your work product. It does include everything else. Correction?
Che at the AG's office disputes that, so.
I just don't want my work product right now is tainting what the Attorney General's office is.
I'm with you. Che and I had conversations about this, but the code, the statute does not speak to it. Work with your AG.
And for those online, the question was, does that include your work product? And there is, I guess, some discussion, and I don't know if Craig wants to add to that. And the concern is not wanting the original prosecution office's notes to taint the review of the AG's office, their decision. But Chair Arguello at the AG's office is the one to touch base with and work through on that.
House Bill 137 is strictly a cleanup bill. So last year, we passed what I colloquially always refer to as the Robinson Act. This was our extreme DUI bill that made enhanced penalties for anybody who was over a 1.6, right, over an 0.5 with any controlled substance, or 2 non-prescribed controlled substances. So one of the issues with that bill is it said if you were over a 0.16 blood alcohol content or concentration, right? which is an accurate statutory definition because in 41-6A-502, our DUI statute, there's actually a statutory conversion for blood and breath, which says that these two are the same thing. So if you're over a 1.6 blood, you're over a 1.6 breath by statute in the state of Utah. However, we're seeing some arguments. There were some judges that were saying, well, that only says blood, so if you're over a 1.6 breath, I'm not going to give you an extreme DUI sentence on this. We're just going to sentence them like we normally would. So one of the cleanups on this is added blood or breath to that. So that argument's now gone, even though in my mind, it wasn't a very persuasive argument. Statute was very clear on its face what 1.6 blood meant. It meant 1.6 breath as well. But that's gone. The other thing is when we did our criminal refusal bill, all right, where if somebody refuses after a warrant has been issued for a blood draw, and we can charge them with that criminal refusal, right? We tried to tie that straight across with all of the DUIs. There was one that was missed, and it was that if you had a child in the car for a Class A misdemeanor. That language has been fixed, and it will apply across the board now. The language is generic. It went to being more generic than being very specific to offenses. And so now, whatever offense of DUI that person is arrested for is going to be what the criminal refusal charge is going to be able to be charged at. Okay? The last one was kind of an interesting one, and it's something that came to my attention. Blair actually pointed this out. There was a weird statutory definition that came in just a couple years ago, and I didn't even know this definition came in until we started looking at it, about a human driver. And there was actually a statutory argument to say that none of our traffic laws applied to somebody who didn't have a driver license. Because a human driver was defined as somebody with a Utah driver license and then other things, right? And all of these traffic laws were tied to a human driver. And so if you followed the rabbit hole far enough, you could get down to the fact that if I didn't have a driver license, then no traffic laws in Utah applied to you. Reckless driving, well, not all the traffic laws. Reckless driving, DUI, a few other things. Obviously, that's an absurd result, right? There's no way our legislature intended to say, just don't get a driver license and you can commit DUI in the state of Utah, right? And so that was a good catch along there. That's now fixed. It actually came in a couple years ago when they were doing some of the automated driving car definitions. And they were trying to differentiate between an automatic car driving and a human driver driving. And it was just something that they didn't even realize the problem that they had caused when they put a definition in it. So, but that's fixed now, no problem. Cleanup on aisle 7's done, and until next year when we get another bunch of crafty legal arguments from defense attorneys and judges as well, we'll clean something up if we have to again.
Senate Bill 123 and its companion bill, Senate Bill 124, have begun a multi-year effort at recodification. Oh, can you pause that?
I can't.
We're not ready yet. Okay.
Watching it on Luke.
We'll leave it on my slide because I don't have a pause it there.
So the multi-year effort is there's a few goals here. And for any Title 76, Chapter 5 or 5B, so think person or sex crimes, the structure of the code has changed starting May 4th. First, we're separating offenses, so there aren't any omnibus crimes anymore. For example, the crime on assaulting a member of the military is also the crime on assaulting a police officer. Those are separated into two separate offenses, so that it'll be easier to track when a specific offense has occurred in the state code. Also, the format has been made consistent, and that format has been changed so that subsection 1 is always definitions, subsection 2 is always the elements, subsection 3 is always the penalties, and subsection 4 is always limitations and defenses when applicable. There may sometimes be subsections 5, 6, 7, but those are mostly miscellaneous. I was worried you might not remember this, and so I got on TikTok and made a video to help you guys remember the new format.
My name is Chicky, 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 Chicky. My name is Cha-Cha, Clop, Clop, Cha-Cha-Cha. Chicky, 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 Clop, Clop, Cha-Cha-Cha. Chicky, 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 Clop, Clop, Cha-Cha-Cha.
Oh, we're not done.
Boom, boom, boom. My name is Chicky, my name is Cha-Cha. Chicky, Cha-Cha, boom, boom. Chicky, Cha-Cha, boom, boom. Chicky, Cha-Cha, boom, boom. Clop, Clop, Cha-Cha-Cha.
Still not done, but this is my Ginsburg.
My name is Lala. La 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 la. My name is Chicky Chicky Chicky. My name is Clop Clop Cha Cha Cha.
My name is Boom Boom Boom.
Chicky Cha Cha.
Boom Boom.
La 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 la. Chicky Cha Cha.
So that's the new recodification.
And how do you follow that? I don't know. I think Will has a career on TV, maybe game show host. He is awesome. Okay, so Senate Bill 156, this is protection against sexual extortion, sextortion. It expands that to an actor threatening the distribution of an intimate image in order to extort a thing of value. So now it's not just where previously we just had to show the goal, but now we can include a threat if we can show that that was for the purpose of achieving that goal of committing that offense. It also expands it to juvenile offenders. There's a reduced level of penalty for it, but it does include our ability to charge juvenile offenders. Unfortunately, this crime is something that our juveniles are engaged in as well, which is incredibly concerning. So that's been extended to them as well.
I kind of feel like I want to watch that video again.
It's a one and done. That is on my private TikTok. I'm sorry you cannot access that publicly.
Will sent me these slides the other day, and I watched it, I don't know, probably 10 times. And that song was stuck in my head the rest of the day. And I just want you all to have the same joy that I had last week when watching that. Fantastic stuff. So, what is marijuana? House Bill 442. Ryan Peters, you worked on this issue a little bit. Nathan Lyons, I think, in Davis County worked on it. This is something that actually has been a topic in Utah for as long as I've been a prosecutor. And it's been kind of, there's been this conflict of law, all right, on the definition of marijuana, the statutory definition of marijuana, and then the statutory definition of THC. And in the law, if you violated possession of marijuana, it was a Class B misdemeanor. If you violated possession of THC, it was a Class A misdemeanor. Well, THC comes from marijuana, right? And so there was this conflict of does the broad definition of marijuana encompass THC? I know that there were jurisdictions around the state that could never charge the Class A. They were just unsuccessful in doing it. I know there were other jurisdictions that were able to do it, okay? And so the idea was to set out to, again, get consistency. And I think the consistency was trying to go one way, but when the bill actually passed, it ended up going the other way. So essentially what we have here is possession of marijuana, possession of THC. It's all going to be a Class B misdemeanor now, all right? So those definitions have been fixed to the point where there's not the ability to go around and do that. So your dabs, your shatters, your waxes, which would fall under that THC definition, are going to fall under the marijuana definition now as well. They'll all be Class B misdemeanors. And this picture you see is me at a marijuana grow. Very proud of that day. This was a very fun day to be hanging out at this marijuana grow in Spokane, Washington.
Is that the day you were voted sexiest man alive?
That was the day that I was, I don't know that it was a vote. There certainly wasn't a Democratic vote taken that day, but maybe dictated that I was such.
House Bill 19, DNA specimen analysis amendments, addresses when somebody's booked into jail on a felony. You may know, but when somebody's booked on a felony at the jail, a buccal swab is taken, the DNA is collected, but it's not tested at that point. The test and the analysis and the entrance into the CODIS all happens after a preliminary hearing or after a waiver and bind over. So the DNA is collected on booking and then it sits and waits. I don't know about you guys, but we have a slight delay in Salt Lake County between original booking and preliminary hearing. We also have some defendants who don't show up for their preliminary hearing.
What?
I know, Salt Lake County only.
Yeah.
But what this bill was originally trying to do is make Utah a test on arrest state, saying that as soon as it's collected, the state lab can analyze it, put it into CODIS, and see if it matches anything else. ACLU, some defense attorneys didn't like that, and so the negotiated bill says that if somebody fails to appear and a warrant is issued for their failure to appear, 2 months later, then the test can occur. So it doesn't have to be a bind over. If they've failed to appear for at least 2 months and the warrant is still outstanding, the test can occur. Why is this relevant to you as prosecutors? Because the sheriff and the state lab aren't going to know when somebody's FTA'd for the last 2 months. You will. And so if you've got somebody who's been out absconding for at least 2 months, you can let the crime lab know, and the specimen can be analyzed at that point. I'm going to talk a little bit about the next bill. The next bill is Forensic Biological Evidence Preservation. This was by Representative King and the Rocky Mountain Innocence Center. This bill specifically delineates time periods for retaining biological evidence, and that is for while a person is in custody. In custody is defined pretty broadly. So while they're on probation or parole, they're in custody. If they're on a sex offender registry, as long as they're on the registry, then they are in custody. If there's a case that has not been filed, you need to retain that biological evidence until the statute of limitations has run. And yes, there are some crimes where there is no statute of limitations. So those that biological evidence needs to be preserved. A question that was raised by the Salt Lake City Police Department is, well, what if we have a whole mattress? Or what if we have a car? Like, sure, somebody probably touched the door on the car. Do we have to keep the whole car? Do we have to keep the whole mattress? Under this legislation, the answer is no, but you do need to keep the portion that's likely to contain the biological evidence. So take off the car door or cut out a piece of the mattress. There are also codified penalties or options for the court if you fail to retain. This is not an automatic reversal if you fail to maintain the biological evidence. But reversal is a possible consequence depending on what is not preserved and the violation. So this is a burden that's really going to be on the local police departments by and large, but it could affect the integrity of your cases long term. So make sure that your officers know about it.
House Bill 143, all right? This is a bill that creates an enhancement for second and 10 DUIs. So we know we had enhanced sentencing provisions for second and 10 DUIs, right? Now you actually have an enhanced charge. So anytime you have a DUI that is a second and 10 offense, it becomes a Class A misdemeanor now. So essentially you start out with Class B on your first bite of the apple, Class A on your second bite of the apple, third degree felony on your third bite of the apple in 10 years, right? Ultimately, I don't think that this is going to change how these DUIs are resolved in any way, shape, or form, right? Will is often quoted as saying, when you create a floor, you create a ceiling, with, at least in Utah, right? Whenever we create these statutory floors, these minimum mandatories, that's what judges will just automatically default to. So just because these are now Class A misdemeanors, I personally don't anticipate that they're going to be handled any more seriously as a Class A than they would have been as a Class B. What this does do is it takes all second and 10 DUIs out of justice courts now, right? They'll all be in district courts. For those of you who don't prosecute your own Class A misdemeanors as city prosecutors, and the counties do that, the counties will now be taking on these Class A misdemeanors, all right? The other thing it's likely to do is it's likely to create a scenario where we're going to start seeing a lot more DUI case law formulated. Because most of our DUIs start in justice courts, and they just have a cap on how far you can get unless we're talking about the constitutionality of a statute, right? And they usually don't go to the Court of Appeals. And so now that these Class A misdemeanors, we're going to have a lot more DUI cases. A lot, that's relative, because we don't get a ton of second DUIs, comparatively speaking. But enough that we're going to have a lot more DUIs in district courts, which means we could start seeing a lot more DUI case law coming out. And to keep Tyson happy, let's not get bad DUI case law, okay? Because I watch my counterparts around the country with some of their bad DUI case law, and I see the headache that it causes. So just make my job easy. Let's not get bad case law. David, you probably agree with me, right?
Yeah. No,
You're on board. You're on board with that. We're unanimous, all right? So we got that. But yeah, that will be a change that may not have a practical impact on defendants on how they're sentenced, but definitely will impact on how things are handled in our system. Yeah, Wayne.
Application question. I've got a bunch of second DUIs before the court right now. Do they stay?
They will stay. Yes. This will have to be a DUI committed on May 4th or later.
Committed?
Yes. Yep.
All right. This one's about use of force revision, specifically when an officer uses force and it comes to the county or district attorney to review. It's a timer. It says that the county or district attorney has 6 months from the time they receive that investigation to produce their findings. And if they don't, that's okay. They just have to say, we're not done, here's when we expect to be done. Additionally, the statute also requires that 5 days after findings have been reached, they have to be published on your website. So if you want to see Salt Lake County's OICI findings, you can go to our website. If you don't have a prong on your county website for OICIs, it's time to create one, because starting May 4th, anything that's 6 months old needs to be published, and if it's not published, you need to give an ETA for when it'll be done. Oh, this is a great bill.
How does that work when we have outside agencies do our OICI?
So the timer doesn't start until the investigation is turned over to you to look at. So if you're outside agent, and I don't know how Kane County operates, but if you don't look at anything that happens in your county, then this obligation wouldn't land on you. But if you've got to deal with another county, the obligation for you would be when you do an OICI for that county. Does that make sense? So it's not a great fit. Protection of animals amendments, House Bill 175. This allows protective orders, specifically civil protective orders, to include prohibition on harming, contacting, or taking animals. Additionally, it defines emotional distress under the stalking statute to include abusing an animal with the intent to cause an impact on the animal's owner. So you guys saw my Ginsburg and Capucho's little bulldog. If my partner decided to hurt Capucho to torment me, that could qualify as a part of a course of conduct under the stalking statute. Or if I filed for a civil protective order against my partner, I could say, also, you don't get to take Ginsburg in that filing for the protective order. It's a great bill.
House Bill 180, off-road vehicle safety education. This bill, you're not going to see this a lot, okay? I'm guessing that this is going to apply to more people on a personal level in this room than into your professional practice, all right? But this does two things. Starting in January of 2023, any off-highway vehicle that is operated on public lands in the state of Utah, the driver of that vehicle has to take an online education course and have a certificate to be able to do so. Doesn't matter if you have a driver license, anything. Everybody has to do that, okay? If you do not do that, it's a $150 fine as part of this. The other thing that it does is if you are under the age of 18 and do not have a driver license, then you have to take the online education course and a skills and safety course as part of being able to operate an off-highway vehicle on public lands in Utah. So like I said, I doubt you're going to see this come. You're probably not going to have a ton of cases of this that comes up, but I'm sure there's a lot of people in here who like driving off-highway vehicles on public lands in the state of Utah. And if you do so, you're going to have to take this course. There are some exceptions. So like if you go on like a razor tour down in Moab, right? And you go part of like a big tour company and you hire them, then there are some exceptions for things along those lines where you don't have to do it. But if you're just out and about, every single person has to do that. Yeah.
So I anticipate that we absolutely will have to deal with this. And the question I have is, will it be required to carry that certificate if they're operating it, or is there a way for whichever law enforcement agency to check their status?
I don't know the answer to that. I'm guessing they have to carry their certificate. I have no idea if they're going to be able to check it online. This doesn't go into effect until January of 2023. Enforcement doesn't start until February of 2023. So, yeah.
We were looking at some issues for one of our cities, and a city golf course is public land under Utah law, as are our golf carts are off-highway vehicles.
I don't think a golf cart actually counts as an off-highway vehicle.
If you look through the different definitions, it can be.
Because I thought a couple years ago, and the only reason why I know this is because I used to tell people they could, I'd go around on my legislative updates. I think golf cart got its own definition 2 years ago. So it's, yeah, I'll get with you after, Steve. It got its own definition a couple years ago where it was kind of pulled out of that umbrella of off-highway vehicle. Bob?
I have a question about a previous bill, so when you're done, let me ask the question from an online person.
I think I'm done. Ask your question.
Okay, so Colleen McGee from Grant County is asking about changing the second DUI to a Class A. Well, APP supervise, since it's a Class A, has anyone reached out to APP to see if they will supervise? Ours in Grant County, they don't have an CGS application service.
So the question is with second DUIs being Class A misdemeanors, will APP supervise, for those who are online and maybe didn't hear that?
Yes, so Class A misdemeanor is the sweet spot under this year's legislation, because a Class A can be supervised by a local supervisory agency as long as they have the capacity, or a private probation provider as long as they're able to provide it, or AP&P. Now, there is a catch. AP&P loves to find DUI drivers low risk and say, well, you know, they're not appropriate. But any of those three that work for your jurisdiction, the local agency, private provider, or AP&P could be inappropriate for a Class A misdemeanor, whether that's DUI or any other offense. All right, the last 2 years have been kind of crazy, right? Healthcare, yeah, maybe it's just me. Healthcare providers have in some times over the last 2 years and in some places been considered to be our nation's heroes. And at other times, they've been considered to be enemies of the state. And they're really in a hard spot. And this bill creates a short-term enhancement. You know that assaulting a healthcare worker is already enhanced if they're providing emergency or life-saving care. That's still in effect, and it will be in effect permanently. But until January 1st of 2027, anybody who works in the healthcare industry can be eligible for the enhancement. So it could be the operator, it could be the front desk clerk, as long as the assaulter knows or should know that the person is a healthcare employee and is working in that role at the time that they're assaulted or threatened, they're eligible for the enhancement. So this is a 5-year stop picking on the healthcare workers bill.
A question about that.
Yeah.
Is that now in security then? Because that's been an ongoing.
It does, as long as they are either employed by or a contractor for, security would be covered. Criminal stalking exception amendments. Yes, I got this. All right, sorry, I'm just looking to see what we're talking about next. Private investigators and police cannot be convicted of stalking. Any questions? So private investigators do need to comply with the licensing requirements, but the problem was some people who were licensed private investigators who were doing their job were being accused of stalking because they probably weren't very good at the private investigator part. They were getting caught. There was a case out of Salt Lake County where we prosecuted someone. We still would be able to prosecute that person because that person was not a licensed private investigator. They were just a new hire temp that was doing some very shoddy private investigation work. Keep in mind, just because you can't charge a private investigator does not mean that you can't charge. Let's say a respondent to a stalking injunction hires a private investigator to go after their victim, but you can still go after that respondent for violating the stalking injunction and as a party to the offense of stalking. So just because the PI can't be charged does not mean that it's a free-for-all on the stalking front.
3 different bills here, House Bill 385, Senate Bill 190, and Senate Bill 195. These were kind of our medical cannabis bills for the legislative session this year. And I've lumped them all together because I'm going to talk about them all together, and it's not going to take very long to talk about these monstrosities that become our medical cannabis bills, because the vast majority of what they do deal with the licensure and other things and certifications that people have to go through and different things for that. A few things that will creep into our world that I want you to be aware of, though, however, okay? Liquid medical dosage form has some updates. Liquid suspension is a valid medical dosage form under the statute. But as of December 1st, 2022, it may not exceed 30 milliliters. Okay, so they're putting a cap on how much you can have in liquid suspension form when it comes to that. Also, aerosol applications will become medical dosage form. So if you've seen some of these things they have, like inhalers that are THC infused, that could become medical dosage form. All right, some things that are not allowed. The statute, one of these bills made very clear that smokable flower is not allowed. Okay, the problem with that is we still have unprocessed cannabis flower as a medical dose, as an appropriate medical dosage form. So somebody in this room who smokes a whole lot of pot is going to have to explain to me the difference between smokable flower and unprocessed cannabis flower. And we can have that conversation offline. We don't need to do it in front of everybody here. But I really want to understand what the difference between those two things are, because they seem and sound a lot the same to me in what we're doing. Again, there was a lot that was done in this, but the vast majority of it was handled in the administrative aspect. There's some clarifications in regards to how much THC by weight is in there, but these are things that you're just not going to come across a lot. Be aware, there's some medical dosage form stuff that's updated. Cannabis or smokable flower, we know that you can't smoke marijuana legally in the state of Utah no matter what, still, for the time being at least. But there were some changes that came along with that.
Here in Salt Lake County, about once a month, we have an officer use of force incident that gets some sort of coverage. Most of the time it's justified, sometimes it's not, but the other people involved are often charged with crimes. And whenever you have an officer-involved critical incident, you've got three different interests that come into play when it comes to the body cam footage. First, you've got the public's interest in what happened down the street. Second, you've got the right of a defendant to have a fair trial and not have everything aired in the public arena before a trial ever occurs. So the right to a fair trial comes into play. And third, you have a privacy interest of family members or an injured person when they've been shot and killed in such a public way. And sometimes that could be a civilian's family members, or sometimes it could be an officer's family member. This bill talks about what to do when an agency receives a request for a release of footage in one of these OICIs. The first step for the agency is to contact the prosecutor to see whether a case has been filed or declined. If the case has been declined, then they are authorized to release the footage. If the case has been filed, then the prosecutor or defense attorney needs to approach the trial judge and ask that judge whether releasing that footage would unduly prejudice a potential finder of fact. Read the ultimate jury. If the judge decides that it could unduly prejudice the finder of fact, then the judge prohibits the release. If the judge decides that it would not unduly prejudice, then the judge authorizes the release. But remember, the third interest I talked about was that privacy interest that individuals or family members have. And that privacy interest is addressed in this bill by saying either the injured person themselves or an immediate family member of someone who is injured or killed in one of these incidents can essentially veto the public release of the footage. And so it takes this body cam footage in OICIs out of GRAMA and creates this three-pronged analysis. Has a case been filed? Is the family against release? And if the case has been filed, does the judge think it would be unduly prejudicial to release the footage? So it's a much more layered and nuanced approach to release. And a lot of that's going to land on you, prosecutors, because even though it's the agency that has the footage, the prosecutor is going to be in the position to know, was the case filed? What does the judge think? And may even be contacted by the family saying, you know, I really don't want my brother's death to be on KSL this evening.
So is GRAMA specifically address that?
No, this says GRAMA does not apply here.
Sorry, does it address who the victim representative could be? Could it just be like a cousin or?
It says immediate family member. So brother probably fine, cousin probably not. Protective order and stalking injunction expungements. Do you want to cover this one?
Please, Will.
Let's talk about it. So if I'm convicted of stalking, or if I'm convicted of violating a protective order, I have the opportunity to get an expungement. That's already current law. But if somebody files a stalking injunction against me, and the judge looks at it and says, "It's ridiculous, there's no way," that is going to be on my record forever. Until this bill passed. This bill specifically says that if a civil stalking injunction or a civil protective order has been denied or has expired, and for the protective order it's been at least 3 years since the expiration, and there was never any arrest or charges related to the stalking injunction or protective order, there can be a filing for an expungement of that civil case as well. So it provides the same protections that we already give to criminal defendants to those who were never charged or arrested for doing anything in the first place.
Senate Bill 53, driver speeding amendments. This bill does two main things. First, amends our reckless driving code, all right? in reckless driving, a willful wanton disregard for safety, person's property, different things like that. And then it tells us that if you commit 3 traffic violations within that time period of driving, that simultaneous driving period, that's reckless driving, right? But that's not the only way we could get reckless driving. We could always show a willful or wanton disregard for safety. Well, now if you were going over 105 miles per hour, that is something that's per se willful wanton disregard for safety now. It doesn't matter what roadway you're on. If you're over 105, you're going to get hit with the reckless driving ticket. All right? It started at 100. The negotiations moved it to 105. There was also a provision in there to finally make 30 miles per hour over the posted speed limit per se reckless. That came out. It didn't pass. But 105 and more is reckless driving. Okay? Second thing that it does is exhibition of speed or a speed contest. That is now a Class A misdemeanor. So you won't be seeing those cases in justice court anymore either. All right? That, to me, is a rough code. That's a rough statute, because unless 2 people are drag racing down the road, I don't know how to actually prove that case. And it's been kind of a code that's always been a bit of a mystery to me. Maybe some of you have been better successful at prosecuting those. But if somebody is getting an exhibition of speed, it is a Class A misdemeanor now. So those aren't going to be in our justice courts. Those will be in district courts. The other part of that is anybody who's participating in the speed contest, like barricading roads, obstructing roads so that they can go do it, those people will be guilty of a Class B misdemeanor now for participating in that. All right?
Oh yeah, let's play this video. It's pretty unsettling.
I've been shot. 999! Tonight, new video showing the moment a Phoenix police officer was ambushed while responding to a call that ultimately left 9 officers shot or wounded. In the video, released, transcribed, and blurred by police, the shooter appears to beckon the officer into the home. Police say they were responding to a 911 call of a woman shot inside. But as the officer approaches...
Who's all in the house? Who's all in the house? It's me.
The officer shot multiple times, according to police. Calls for backup.
999! I've been shot. 999!
It led to a standoff at the home. As more police arrive, a man emerges from the home with a baby, placing the child on the ground before being detained. But as officers move in to rescue the child, more gunfire. The alleged shooter, identified by police as 36-year-old Morris Jones, was found dead by suicide inside the home, according to police. The woman police received the initial call about, who they believe to be the shooter's ex-girlfriend, also dead, shot fatally, police say. Remarkably, those 9 officers and the child all survived.
I think we were all afraid.
One of those officers now speaking out for the first time since the shootout.
I didn't know what getting shot felt like, but it hurt. I did a quick kind of check for blood, didn't really see any blood. So I continued on.
His superior praising those heroic efforts.
They ignored their own pain and all that other stuff that was going on to make sure that they could complete the mission.
I didn't really fear for myself. I was kind of in fear for the community and where those bullets were going, really.
All right, Priscilla Thompson joins us now live in studio. So Priscilla, we saw that man take out the baby there. What's the story there, and who was that man?
Yeah. Well, Tom, police describe that man as a family member. They say he was following their orders and putting the baby on the ground and walking out to be detained when another round of gunfire erupted. Police say he sustained non-life-threatening injuries. They do not believe he had anything to do with this ambush. But of course, this investigation is still ongoing. And some good news as it relates to those 9 officers. Those who were hospitalized are now all back home.
Yeah, every year.
Thanks for watching.
Oh, thank you. Every year, there's at least one criminal bill where there's a new crime, and I ask myself, is that even a thing? And I'll admit, when I first saw this bill that said it's a second-degree felony to call for police aid with the intent to ambush the police, my first impulse was, is that a thing? And one quick Google search, and it is a very prevalent thing. So this bill makes it a second-degree felony to call for emergency aid with the intent to ambush, harm, or threaten the police or other first responders. It is a thing. Hopefully you never have to deal with it, but if you do have one of these cases, starting May 4th, it'll be a second-degree felony. Senate Bill 167, sexual exploitation amendments. This one does a few things. And I'm going to go to somebody else's notes for just a minute, because otherwise I'm not going to do it justice. Senate Bill 167. All right. It separates out the production and distribution of child pornography from possession and viewing. Production and distribution are now first-degree felonies, and possession and viewing will remain second-degree felonies. It also directs the Sentencing Commission to put into effect new guidelines specifically tailored to sexual exploitation of a minor, as a practice to keep an eye on your specific mens rea requirements, because you need to show intentional distribution or knowing production. So for possession and viewing, the mens rea is not as high, but if you're going to go for the first, you got to show intent or at least knowledge on that front.
Senate Bill 102, wireless communication device in the motor vehicle. There are some updates when it comes to wireless communication devices. They're not huge. It's not going to significantly change what you're doing. The definition was updated from a handheld wireless device or wireless communication device to just a wireless communication device. So it doesn't actually have to be handheld to get you in trouble anymore when under the definition. And then some prohibited conduct was updated. So taking a picture, or the video was already against the law. Taking a picture while operating a vehicle is against the law. Viewing a picture or any of those things is against the law. It updated that. This bill actually, and it didn't pass this way, but it actually had a provision in it that if you were using your handheld device at a stoplight, you would have been guilty of this. So you see people that pull out their phone at a stoplight and start looking at something, whatever, right? But that didn't pass, which was interesting that that was in there, because we haven't been able to get them to pass a handheld driving law ever, right? Every time that comes up, the legislature kicks that out. And I'm like, and now they're going to pass one that if you're doing it at a stoplight, but not while you're driving? The
difference is the sponsor was a Republican this year.
There you go. There you go. Which makes a difference in the state of Utah, certainly. So be aware of some changes on that. Again, not huge changes, but there are some technical changes that may impact some of your cases when they come to you.
2 sessions ago, there was a bill that really tried to limit using mugshots in news stories, saying that you could only use a mugshot if it was attached to a conviction. The idea was we don't want to tarnish somebody's reputation if they may end up being acquitted or having the case dismissed. As written, the bill also restricted your use of mugshots in 1102 statements, or in showing them to a victim or witness to say, is this the person in this offense? This bill, House Bill 406, specifically authorizes the use of mugshots for the specific case to provide to private citizens and provide in court proceedings such as an 1102 statement for a preliminary hearing. Crime victim reparations amendments. This one I think of as the Maslow's hierarchy. The last training talked a lot about Maslow's hierarchy of needs. You need your basic physical needs met, and then your psychological needs met, and then you can go on to self-actualization. This bill says you don't, as a victim, need to cooperate with the police or the prosecution in order to receive crime victim reparations when you are a victim of sexual violence or domestic violence. Again, at first blush, the concern from some prosecutors was, well, won't that just mean that they're not going to cooperate because they can get the money and they don't have to do anything? But realistically, if someone is feeling so unstable that they don't know where they're going to live, they don't know how they're going to feed their kids, they're not in a position to be your witness in any sort of criminal justice proceeding. The hope is that providing these reparations independent of participation with police and prosecution will ultimately lead to more cooperation with law enforcement and prosecution. If it doesn't pan out that way, we can address this in the future. But this is based on that Maslow's hierarchy that you got to take care of the basic needs first, and then we can go for the self-actualization of justice down the road.
Who's all ready for the zipper merge? You guys hear about this one? House Bill 76, zipper merge. It is a new requirement in the state of Utah on how you merge, all right? And the diagram up on your screen up here will tell you how to do the zipper merge. So anytime you have a pinch point, right, where a lane either ends or there's a crash and they've got that lane blocked off and you need to merge over, this is the new method that is required to be used in the state of Utah. You go all the way to the pinch point, right, and then it's every other car just like a zipper. It goes in. That's how it's supposed to be. The early merge, all those other things, I'm going to speed out around everybody else and get up there, all those things are a thing of the past. We know nobody's ever going to do any of that anymore. And this is going to be perfectly followed, and the zipper merge is going to solve all of our congestion problems on the freeway every time there's a crash or anything else. And so thank goodness to HB 76, all of our lives are now better.
So Tyson, if I merge over 3 blocks before the pinch point, have I broken the law?
Technically, probably yes.
If I let at the pinch point 2 cars go instead of just 1, have I broken the law?
Yes, you have. And those are serious violations. You will be held accountable.
The worst infraction. I think I see a new law and order in our future.
I'm game.
All right. The next bill, juvenile justice modifications. In theory, there are 2 ways to get a juvenile into district court. There's direct filing for murder and ag murder and the certification process. In reality, there's only one way, direct file. I have not heard of anyone successfully getting the certification of a minor because the juvenile judge has to find that it's in the minor's interest to get them out of juvenile court and put them into district court, which seems a bit of a stretch. But if you'd ever do that, congratulations. And even if you get that conviction in district court, the juvenile can stay in juvenile justice services custody until the age of 25. So for those cases where you feel like there's more to be gained for the juvenile in the juvenile system than sending them straight to prison, this bill says even if you get them into district court through a direct file or through the mythical certification process, and the conviction occurs, they go back to JJS custody until the age of 25, at which point they can spend the rest of their term at the Utah State Prison, which is pretty fancy out there by the airport. By
The new prison.
Yeah, opening next month. Very nice.
Yeah. Victim address confidentiality program. I can take this one, Will. This creates a state-run system, essentially, that allows victims to keep their addresses private. Okay, not have to disclose it in public records or anything else. We were down at Train the Trainer, and we had a short presentation on how to look up people and find people. It was shocking how easy it was to find out what I thought was my unlisted cell phone number and address and everything else, and known cell phone numbers and addresses of my known associates, including my wife, my brother, my cousin. They were all listed there. And so you can see where this becomes a problem. So victims of sexual assault, domestic violence, human trafficking, or stalking, as well as their children or dependents who live with them, okay, can apply for this program. They can get an assigned address. Okay, if they qualify for the program, there's going to be a vetting process and everything else that goes through this, but they can get an assigned address where they can receive mail, their vehicle registration, other things can all be to this assigned address so that they don't have to disclose publicly their address and whereabouts if they meet these criteria. So just a good bill trying to protect some of our victims and keep them from any public knowledge. Anything you want to add on to that?
Fantastic bill, thanks to the tireless work of Darcy Goddard.
Right there. All right, this bill right here, I'm renaming this bill from House Bill 62 to the Rob Van Dyke Act. All right, and so.
Are you the only one that will enforce it?
No, we all know Stephen got the award too. His award's a little bit better than yours, but that's okay. So we had a fun discussion the other day. Apparently, the DNR gives a DNR Prosecutor of the Year award, and Rob got the award, and so I'm going to name this bill after him. I've got everybody's names blacked out on these pictures. I've got outfitter logos blacked out to protect the innocent, because what you see on the screen right now is currently and in the past has not been illegal. Okay? But what you see on the screen right here will now become illegal. All right? So what this does, big game amendments. People who are out in pursuit of big game, all right, they can only hire one outfitter. Now, you who have prosecuted these cases know that, especially at a high-priced animal, some of these outfitters get together, right? And again, I'm going to protect the innocent, so I'm not going to name any names, but they might rhyme with Bossback. They might rhyme with Wade Lemon Hunting. They might rhyme with, some of these others, right? Some of these major outfitters in the state of Utah that guide big game, and there's others. And sometimes they'll coordinate and they'll get together and they'll say, hey, I know where an animal is. Pay me and I'll take your big high paying client to go kill this big animal. And they do it, and they slap their logos on, and they have 15 guides in the picture with them when they do this, and that has all been fine, but now it's not legal anymore, all right? You can hire one outfitter, and with that outfitter, they can pay one person to pursue that big game animal with you. That's it. So no multiple outfitters, no teams of 15 people going out and pursuing that animal with these people anymore, okay? So that is a change that is in our big game code, our wildlife code that will go there. One thing I do want to point out with this is everybody in the room is probably sitting here saying this is a rural Utah problem, right? It's really not. There's not a county in our state that we don't have trophy big game animals that are sitting in that outfitters and other people are paying immense amounts of money to go and chase. Salt Lake County has them, Utah County has them, Weber County has them. Everybody has this, and so it's something that has the potential to creep up on your radar, and it's actually a huge change in the outfitting world. And so even though Rob Van Dyke had nothing to do with this bill, I actually know how this came about, and he had nothing to do with it. I'm calling it the Rob Van Dyke Act because he is the DNR prosecutor of the year, and that just is a big deal. So thank you, Rob.
I couldn't care less about this bill.
It just means Rob's going to have to prosecute more cases to keep his reign as the DNR prosecutor of the year. So,
You know, there is a myth or a legend that if you want to make sure the bill ends up being unconstitutional, you name it after a person. So you may have just made this bill unconstitutional by making the Robert Van Dyke bill. I complained earlier about Senate Bill 179 and the mandates on criminal justice coordinating councils, but I want to be clear, I like them. The multi-stakeholder at the local level comes up with good ideas. And CJAC, which is Salt Lake County's Criminal Justice Coordinating Council, came up with Senate Bill 35 expungement modifications. The goal was to make expungements more clear and better. And it does a few things. One thing it does is it says that if you're a respondent to an active protective order, like a continuous protective order or a permanent stalking injunction, you can't expunge that case. It seems pretty common sense, but that was something that we were getting petitions for where someone had a continuous protective order in place on a case that they wanted to get expunged, and they were statutorily eligible for an expungement. This says that that's no longer the case. Minor traffic offenses will automatically be deleted from your record 5 years after adjudication for infractions in Class C misdemeanors, and 6 years after adjudication for Class B misdemeanors. Now, to be clear, DUI is not a minor traffic, so that's not going to automatically expunge. Defendants who are currently on probation or parole can't get cases expunged while they're on probation or parole. Again, this came up because people were getting expungements while they were on probation, and BCI was saying, well, that's not a pending case because they already have been found guilty. But this says you can't get it expunged while they're still on probation or parole. If a defendant stays crime-free for a decade after finishing their last case's incarceration, probation, or parole, the numerical limits on expunging Class B misdemeanors and below dissolve. Right now, there's this weird math formula that's almost like trigonometry, that if you've got 3, then you're eligible, but if you've got 4 and 2 are Class B, then you're not. But if you wait for 10 years, then you can have 5. And this just says when it comes to B and below, if you've been crime-free for a decade, they're eligible. You can get them cleared off. Also, and this is a big deal, this is a huge deal, this is a fantastic deal, prosecutors can talk to each other about cases that have been expunged. Specifically cases that are domestic violence, stalking, weapons offenses, and sex offender registry eligible offenses. There's this language in the statute that says even after a case has been expunged, a prosecutor can ask that it be unsealed if it can be used for enhancement or its sentencing. Problem is, you never knew about it because the prosecutor who got the conviction couldn't tell you about the new case because the expungement order had been in effect. This opens the door for us to communicate with each other. It doesn't say how. It doesn't provide any funding or resource to do so. But if you've got someone that it seems like they're a repeat offender, or it's someone who's just moved from another jurisdiction, you're able to reach out, and even if the case is expunged, you're able to share that information with each other as prosecutors and fellow ministers of justice. It's a great bill. And this one, juvenile justice changes.
I can at least.
All right, Tyson.
I can hit some highlights.
For the children, will you?
Yes, I promise you I will not be able to give you everything on this bill, however. An interesting change when it comes to this bill. Felony offenses committed at school by an 18-year-old can go to juvenile court now. So you may see an 18-year-old who committed the offense when they were 18 showing up in your juvenile court. So don't just make it an automatic, oh, this person's 18, we're booting it to district court. You're going to have to look at those things a little bit more closely, figure out, was this a felony offense that was committed at school, all right, when it does that. It also says that the juvenile court can deal with children who commit boating offenses. So we know that some of those traffic offenses don't always go to the justice court, right? They'll sometimes go to the juvenile court. It creates a provision for them to be able to go to the juvenile court as juveniles and not be handled automatically there. There's some restitution changes that I 100% am not going to be able to tell you what they are.
So I can tell you about this one.
Yes, go ahead, Will.
So one of the restitution changes is for complicated restitution for a juvenile, there was a limited amount of time, like 6 months, that the judge had to consider, like, what can the juvenile pay in the next 6 months? But if it was complicated and it took the judge a while to figure out the restitution amount, the clock had already started on the 6 months. So if it took 5 months for the judge to figure out how much the juvenile could pay for 6 months, then they only had 1 month left to actually get the juvenile to pay. This makes it clear that the clock doesn't actually start till the judge orders the restitution. So it's still a 6 month limit, but the 6 months doesn't start until the restitution order is in effect. That was something I knew.
Hey, there you go. Yeah.
For the part having to do with the 18-year-old committing a felony at school, does it have to still be a student, or is it any 18-year-old?
I am guessing they have to be a student, but I don't know the answer to that. The question for those who maybe weren't online or who are listening online is the 18-year-old commits the felony on school property or at school, does it have to be a student to go to juvenile court? I don't know the answer to that.
This is an area where I'd encourage you to look at the code. I can't say off the top of my head.
Any juvenile court prosecutors that were aware of this that want to answer that?
It says high school student.
Okay.
All right.
Okay, there you go.
So early grads are out of luck too.
Thank you. All right. Senate Bill 149, tinted windows on vehicles. Got a change that will put us closer in coordination, I guess, with surrounding states. We're still not to where some states are, but your windows get to be a little bit darker now. All right. So instead of a 35% transmission, we can go reverse that. Instead of a 43% light transmission, we go to 35% transmission. Just means your windows get to be darker. One thing that's also interesting about this is it allows a 5% basic wiggle room. So if the officer does a check and it's like 32%, then it's still going to be compliant even though it's over the 35%. Does that make sense? There's a 5% wiggle room in how the officers are checking that light transmittance. And so, again, this is a huge deal. It's going to change your world. It's probably going to affect more people personally than it will professionally. If you want your windows darker, you can go get them a little bit darker now.
All right. In the category of, is this really a thing? In the gun debate nationally, I've heard this saying, you know, guns don't kill people, people kill people. Well, in this bill, drones don't commit crimes. The people who operate the drones commit crimes. So you can be guilty of an offense if you control a drone that actually commits the offense. Like groundbreaking, right? Unlike the ambush of officers, Google did not help me figure out why this is a law, but you can't get away with committing a crime just by using a drone to do it.
Custodial interference, this is the one.
Using a drone?
Your drone is operating the vehicle for you?
You're operating a drone while it's
I don't know, a drone probably doesn't count as a vehicle.
Yeah, probably not as a vehicle, but you could get a public intox through your drone if you're a danger to yourself or others. So,
one more question.
Oh, yes.
What about burglary, where you're talking about entrance of the body? So throw in a body to the person's burglary?
The question for those online is burglary. Would this count as the drone doing the breaking or the entering, right?
If you fly a drone into a location or into a residence, say, then yes, you would be committing a burglary if it was unauthorized. Yeah. So it could open the door, depending on how many drones are in your jurisdiction. Custodial interrogation amendments. Don't lie to kids. That's this bill. So this bill specifically is about interrogating a juvenile. And we've had this come up recently in Salt Lake County. It's not about interrogating someone who committed a crime while they were a juvenile that is no longer a juvenile. It's only about interrogating a juvenile. So if you're interrogating someone under the age of 18, you can't give them false information about the evidence that you have or a promise of leniency that's not authorized. This doesn't mean that you can't interrogate. And with just a slight revision, you'll be fine. For example, you cannot say, Johnny's in the other room and he just told us everything, so you might as well confess if Johnny didn't actually do that. But you can say, Johnny's in the other room, and if he tells us everything and you don't, that's going to be bad for you, so why don't you just tell us what happened? Or, we collected a gun. If you haven't tested it for DNA, you cannot say, we found your DNA, but you can say, we're going to test it for DNA, and if we find your DNA on it, that's going to be a real problem for you. Also, you can't make any unauthorized promises of leniency, so you may have officers reaching out to you saying, can I commit to X in this case? And as long as you authorize it, they can make that promise of leniency.
House Bill 329 is my absolute least favorite bill of the legislative session, and that's why I put it last on my list to cover. All right? 7610-528, possession of a dangerous weapon while under the influence statute. All right? That statute requires that if somebody's over a .05, right, with alcohol, or meets the definition of DUI, so would be impaired, and they're under the influence of alcohol or a controlled substance, then that makes them guilty of possession of a controlled, or possession of a dangerous weapon under the influence, right? A couple years ago, we had a bill pass that exempted marijuana. So if somebody was under the influence of marijuana, they could never be guilty of this offense of possession of a dangerous weapon, okay? And that kind of opened the door, so everybody's favorite drug now is going to get exempted. Rest easy that anybody who is taking ADHD or ADD medication as prescribed, you won't be found guilty of possessing a dangerous weapon while under the influence. Now I've got to ask myself, people who have ADD or ADHD and are taking their medication as prescribed, are they under the influence? They're not, right? They're not impaired when it comes to that. And so I don't know where, Will asked the question earlier, like Google didn't help me find an answer to this. I have no idea where this came from. I don't know that it's ever, like you would never have charged somebody with that anyways. But if it's ADD or ADHD medicine being taken as prescribed, don't tack on the charge of possession of a dangerous weapon while under the influence.
Protective order revisions. Don't cross this line. There was a problem with seeking a protective order if you had moved out of the city where you lived. And that was you had to go back to the city where you used to live to actually look for protection, to file for a protective order. This bill expands protections for victims so that they can file requests for protection where they are temporarily domiciled. So if someone is on the border of Davis and Salt Lake County and they cross the county line when they move out of their home for protection, they can file in the new county for the protective order. It's not restricted that they have to file for protective order specifically where they used to live if they've had to relocate. It's a great, very victim-friendly bill.
That's it.
That's it on the justice front.
Thank you.